Well, later today, a landmark civil rights case is set to be argued before the Supreme Court.
And the question is, what should be legally considered when deciding if an officer's use of force is justified?
Give us transparency in how you're going to handle them. And if there's a roadmap of what you're going to follow that's more clear, then it's going to be a fair process for everyone.
There's a Supreme Court document circulating through legal circles right now that has police departments, civil rights attorneys, and gun owners all scrambling to understand what just happened. It's not about abortion, it's not about elections, it's not generating cable news hysteria or social media firestorms, but it might be the most consequential ruling for personal freedom issued in years. Here's what makes it extraordinary. All 9 justices agreed. In an era where the Supreme Court splits 5-4 or 6-3 on virtually everything, where political divisions seem to infect every legal question, the court issued a unanimous 9-0 decision that fundamentally rewrites how the Fourth Amendment protects citizens from government force. The case is called Barnes versus Felix, and on the surface, it's about a police shooting during a traffic stop. But the court's opinion reaches far beyond one tragic incident. It establishes a completely new framework for evaluating when police use of force crosses constitutional lines. And here's the twist that most people are missing. This ruling doesn't explicitly mention the Second Amendment, but it might be the most important gun rights decision in years, because it changes how every armed citizen will be treated during traffic stops, home visits, and routine encounters with law enforcement. The old rules of engagement just got thrown out. Courts that have been rubber stamping police conduct for decades using a narrow, officer-friendly standard just got overruled completely. And the new standard demands something revolutionary: context, accountability, and constitutional depth. What follows is the story of how a single case dismantled legal doctrines that lower courts relied on for years, why gun owners should be paying very close attention, and what this means for anyone who has ever wondered whether courts would actually examine all the facts when police claim they felt threatened, because the Supreme Court just answered that question with a resounding yes, and that changes everything. The constitutional crossroads nobody saw coming. For years, constitutional scholars treated the Second Amendment and Fourth Amendment as separate domains, one protecting gun rights, the other protecting against unreasonable searches and seizures. They existed in parallel universes, rarely intersecting in meaningful ways. Barnes versus Felix just collapsed that separation entirely. Here's the connection most people miss. The Second Amendment protects the right to carry firearms. But that right means nothing if the Fourth Amendment doesn't also protect citizens from being wrongfully harmed simply because they're exercising that right. Think about the practical reality. More law-abiding gun owners are finding themselves in tense encounters with law enforcement, traffic stops where they inform officers they're carrying legally, home visits based on red flag laws or mistaken identity, routine interactions where a legally holstered weapon becomes visible. In these situations, use of force can escalate with terrifying speed, and until this ruling, courts mostly ignored what led up to that force, focusing only on the final split second when an officer perceived a threat. That narrow focus created an impossible situation for lawful gun owners. An officer could misunderstand a legal action as threatening, use lethal force, and courts would evaluate only that final moment of perceived danger, not whether the officer's earlier decisions created the dangerous situation, not whether the citizen was acting lawfully, not whether better de-escalation could have prevented tragedy. Barnes versus Felix changes that framework fundamentally. It allows courts to examine the full context, including whether officers misunderstood legal conduct as threatening. For gun owners, that could be the difference between being wrongfully blamed for a fatal misunderstanding or having courts recognize that constitutional rights were violated. The Fourth Amendment and Second Amendment are now deeply intertwined in ways they've never been before, and that convergence creates a shield that every armed citizen needs to understand. The 5-second encounter that reached the Supreme Court. At the center of this constitutional earthquake is a tragic encounter that unfolded with horrifying speed. Officer Robert Felix Jr. conducted a traffic stop on Ashton Barnes, who was suspected of vehicle violations. The interaction escalated rapidly. The officer asked Barnes to exit the vehicle. Barnes opened the door and initially appeared to comply, but then suddenly attempted to drive away. Officer Felix reacted instinctively, jumping onto the vehicle's door ledge as it began moving. Within 2 seconds, literally 2 seconds, he fired 2 shots into the car. Barnes was hit and fatally wounded. The entire sequence from vehicle movement to fatal gunfire lasted approximately 5 seconds.
Don't fucking move! Don't fucking move!
5 seconds that would eventually reach the highest court in the nation. In the aftermath, Barnes's mother filed a lawsuit arguing that her son's Fourth Amendment rights had been violated through excessive use of force. The central question wasn't whether the shooting was tragic. Clearly it was. The question was whether Officer Felix acted lawfully in that instant of perceived threat, and more fundamentally, what legal standards courts should use to evaluate split-second decisions with permanent consequences. That question had been answered one way by lower courts for years. The Supreme Court just gave a completely different answer. The legal doctrine that protected police for decades. Lower courts, particularly the Fifth Circuit Court of Appeals, had long applied something called the moment of threat rule. The concept seems straightforward. Courts evaluate an officer's actions only at the exact moment force was used, not what led up to it, not what happened afterward. If the officer felt genuinely threatened in that split second, the use of force was considered justified. Period. Context didn't matter. Prior decisions didn't matter. Whether the situation could have been de-escalated earlier didn't matter. All that mattered was whether a reasonable officer would have felt threatened at the precise instant the trigger was pulled or the baton was swung. That's exactly what happened in Barnes's case. Both the District Court and the Fifth Circuit sided with Officer Felix, ruling that the 2 seconds where he clung to a moving vehicle while Barnes attempted to drive away justified deadly force. The moment of threat, officer on moving vehicle perceived danger, was deemed sufficient. Case closed. But this narrow temporal focus created a profound problem that the Supreme Court couldn't ignore. Critical questions were being systematically excluded from judicial review. What led to the officer jumping onto the vehicle? Could the situation have been de-escalated before it reached that point? Were Barnes's earlier actions actually dangerous, or were they misunderstood or mischaracterized? Under the moment of threat doctrine, those questions were legally irrelevant. Courts weren't allowed to consider them, and that's precisely what the Supreme Court found constitutionally unacceptable. The unanimous rejection that shocked legal experts. In a 9-0 decision written by Justice Elena Kagan, the Supreme Court didn't just modify the moment of threat doctrine, they rejected it entirely. The opinion was unequivocal. Excessive force cases under the Fourth Amendment must be evaluated based on the totality of circumstances. That seemingly simple phrase, totality of circumstances, represents a seismic shift in constitutional law. Here's what it means in practice. The entire interaction becomes relevant. An officer's decisions leading up to the use of force matter legally. Courts must weigh whether the force used was objectively reasonable from the perspective of a reasonable officer at the scene, considering everything that happened, not just the final moment. Justice Kagan's opinion emphasized that the totality of the circumstances inquiry has no time limit. Earlier facts may demonstrate why an officer would reasonably view ambiguous conduct as threatening, or conversely, why that conduct was clearly harmless. Context isn't just helpful, it's constitutionally required. This establishes binding precedent for how excessive force gets evaluated nationwide. Every federal court, every state court interpreting parallel state constitutional provisions must now apply this broader, more comprehensive analysis. The days of evaluating police shootings based on isolated split-second snapshots are over. Why this changes everything for armed citizens. Here's where the ruling's implications become crystal clear for anyone who carries a firearm or cares about constitutional limits on government power. Gun owners are statistically more likely to encounter law enforcement than many other demographic groups. Traffic stops, range checks, hunting license verification, welfare checks at homes. The opportunities for interaction are numerous. What happens in the first few seconds of those encounters can be life-altering or life-ending. Until Barnes versus Felix, if an officer claimed to feel threatened by a lawfully carried firearm and used force, courts would typically evaluate only that final moment of perceived threat. The fact that the citizen was acting entirely legally, that the weapon was properly holstered, that the citizen had informed the officer appropriately, none of that context necessarily mattered under the moment of threat standard. This created an impossible situation. Exercise your Second Amendment right to carry, but if an officer misunderstands or overreacts, courts won't examine whether that officer's actions leading up to the shooting created the dangerous situation unnecessarily. That asymmetry just got corrected. Now, courts must examine the full timeline. If an officer escalated unnecessarily, if better de-escalation tactics were available, if the citizen was clearly acting lawfully and the officer's training should have recognized that, all of it becomes admissible and relevant. This doesn't make all use of force illegal or unjustified, but it dramatically raises the legal standard for claiming justification. and it creates meaningful accountability where very little existed before. The new framework that courts must follow. The Supreme Court didn't just tear down an old doctrine, they constructed something better in its place. The totality of circumstances framework creates a clearer, more constitutionally grounded approach to evaluating police use of force. Here's what courts must now consider: the full timeline of events from initial contact through the use of force and aftermath, whether the officer's earlier decisions or tactical choices created or escalated the dangerous situation, prior interactions, behavioral patterns, verbal cues, and de-escalation attempts, whether the perceived threat was objectively reasonable given all available information, not just the officer's subjective fear. This represents a fundamental rebalancing. Officers can no longer claim justification based solely on perceived threat if that threat was substantially shaped by their own poor tactical decisions. The citizen's conduct throughout the entire encounter becomes relevant, not just the final ambiguous movement that preceded gunfire. For self-defense cases, wrongful shooting lawsuits, and encounters involving lawful gun owners, this changes everything about how cases get litigated. Evidence that was previously excluded as irrelevant under the moment of threat doctrine suddenly becomes central to the constitutional analysis. That's not a minor procedural adjustment. It's a complete transformation of how these cases will be argued, evaluated, and decided. The ripple effect spreading through the justice system. This wasn't just a correction aimed at the Fifth Circuit. It was a direct challenge to how multiple federal appeals courts have handled excessive force cases for decades. Some circuits had adopted versions of the moment of threat rule. Others applied broader standards, but inconsistently, depending on the panel of judges hearing the case. Now every court is on notice. Here's what's already happening. Lower courts are being forced to reevaluate pending excessive force cases using the new standard. Appeals from previous rulings decided under the narrow moment of threat doctrine are being revived and reheard. Future cases will cite Barnes versus Felix as binding precedent. That context must be examined comprehensively. In practical terms, this ruling is reshaping federal jurisprudence across all 50 states simultaneously. Civil rights attorneys representing victims of police overreach now have a Supreme Court-approved argument that context is constitutionally required. That gives new legal life to cases that would have been dismissed as unwinnable under the old framework. Police departments are scrambling to update training and policies because officers must now account for how their actions before a shooting will be examined and potentially criticized in court. The incentive structure just shifted dramatically toward de-escalation and restraint, the message that transcends politics. Perhaps the most remarkable aspect of Barnes versus Felix is the 9-0 vote. In an era of deep ideological division on the court, where most significant cases split predictably along conservative-liberal lines, this unanimous ruling sends an unmistakable message. Constitutional rights aren't political, they're foundational. Justice Elena Kagan wrote the opinion, but she was joined by Chief Justice Roberts and Justices Thomas, Alito, Sotomayor, Gorsuch, Kavanaugh, Barrett, and Jackson. Every ideological perspective on the court agreed that the moment of threat doctrine was constitutionally inadequate. That unanimity amplifies the ruling's authority exponentially. Lower courts cannot dismiss this as partisan judicial activism or ideological overreach. It represents the entire Supreme Court speaking with one voice about fundamental constitutional principles. And that might signal the beginning of a new era in how police powers are restrained, rights are enforced, and citizens are respected under the law, not through political preference, but through constitutional mandate. So here's the reality that's still sinking in across the legal system. A Supreme Court ruling that received minimal media attention just fundamentally altered the balance of power between citizens and law enforcement. The moment of threat doctrine that protected police from accountability for decades, gone, rejected unanimously as constitutionally insufficient. The narrow temporal focus that excluded critical context from excessive force cases, replaced by a comprehensive totality of circumstances standard that demands courts examine everything. For gun owners specifically, this represents the most significant Fourth Amendment protection in years, even though the case doesn't explicitly mention the Second Amendment, because the right to carry firearms means nothing if exercising that right makes citizens vulnerable to unjustified force that courts refuse to scrutinize properly. Barnes versus Felix changes that equation. It creates legal breathing room for lawful conduct. It demands accountability for officers who escalate unnecessarily, and it recognizes that constitutional rights require context, not convenience. This isn't the end of police authority or the beginning of chaos in law enforcement. It's a recalibration toward constitutional balance, ensuring that when force gets used, Courts examine whether it was truly necessary given all the circumstances, not just whether an officer felt threatened in an isolated moment. That's not radical. That's what the Fourth Amendment has always required. The Supreme Court just reminded lower courts of that fundamental principle, and in doing so, they may have issued the most consequential ruling for personal freedom that nobody is talking about. The question now is whether citizens, gun owners, and rights advocates recognize what just happened and understand how to use this new legal framework to protect constitutional freedoms. Because the rules just changed, and they changed in favor of accountability, context, and rights. That's a victory worth understanding deeply.